If we meet those burdens that will sustain additional charges, we will present them to the chamber, and it will be up to the chamber to decide. Thank you, Your Honors.
Thank you very much, Mr. Prosecutor. Well, now is the time for the legal representative of the victims to make their closing statements. Ms. Masida, can you please tell the chamber what are the arrangements with you and your colleagues? Thank you.
Yes, Your Honor, I am ready to start for the legal representative. With the indulgence of the chamber, it may be necessary for Ms. Clooney and Ms. Amin to conclude after the lunch. I understand they are coordinating amongst them, but I'm certainly ready to start, and I will take, I think, 25 minutes.
Okay, well, you know, you've been given 1 hour. The thing is that I could accept the request of the two other legal representative victims, provided that they will not exceed the time, because then we need to give 45 minutes to the defense. And of course, I will not curtail
I see my colleague nodding.
The time of the defense.
Yes, Your Honor, I'm very grateful for your indulgence, and I can confirm that we won't exceed, between the two of us, the half an hour that I believe we have allocated for the legal representatives.
Then, Ms. Masida, please, the floor is yours.
Thank you very much, Your Honor, much obliged. Mr. President, Your Honors, I have few remarks following the defense presentation. As explained in our opening statements, victims have waited for justice for almost 20 years, and they are following these proceedings. As you can imagine, the main line of arguments developed by the defense yesterday was particularly unacceptable for victims, and they have asked me to convey the following views and concerns. First, on the fact that Mr. Abd-Al-Rahman is not Ali Kushaib. All of them, participating victims and persons who are still applicants, recognize the suspect as the person who inflicted on them or on their family members sufferings and caused their displacement, leaving them destitute today. I aver, Mr. President, Your Honors, that this identification by victims is not to be regarded as evidence. But can such a large number of people really be mistaken? But what is more, victims insist on the following issues. On the Kushaib nickname. According to defense counsel, it took a lot of efforts to find the sense of the meaning of the nickname Kushaib, and eventually reach the conclusion that it has something to do with alcohol. Now, Your Honors, the victims we represent are all Darfurians. They know their language. So maybe the defense should know that Kushaib has indeed two meanings. One, alcohol, only in West Darfur. Not really popular nickname, but referring to a tough fighter in a much more accepted meaning. Finally, on this point, Your Honors, I incidentally note that Mr. Abd-Al-Rahman himself acknowledged it is his nickname in the video, which was just shown by the prosecution 15 minutes ago. Second aspect, On the discrepancies regarding the year of birth of a suspect. Age in Darfur is not significant at all. It is based on an estimation, as also recognized by the defense on Thursday and also this morning. Actually, Your Honor, if you lose your birth certificate, the authorities of the Ministry of Health will issue you another one, likely to contain a different year, because they will just estimate your age, as there is no database recording these kinds of data. Or at least there was no database at least very recently. So, Your Honor, your date of birth will likely to be the 1st of January in any event. And on this point, I assure Your Honors, you have certainly noted in reviewing the application forms of participating victims that practically all are born on 1st of January in a certain year. Third point that the victims would like this chamber to hear. On the ethnic composition of the Janjaweed militia. Abd-Al-Rahman, as acknowledged by the defense, is from Taisha ethnicity. The Taisha are Arabs, although of darker skin color. But this is not really so important, since in any event, people from non-Arab ethnic groups also join the Janjaweed for financial purposes, contrary to Ms. Flint's study as read by the defense yesterday. Indeed, as already explained yesterday during my opening statements, the wealth of the Darfuri people is not based on salary, but on cattle sites. And whatever the salary of Mr. Abd-Al-Rahman was, as repeated several times by the defense in its presentation, thanks to the pillages, he was a very wealthy man. So were the members of the Janjaweed. And in any case, contrary to the defense assertions, the Janjaweed was not composed only of Rizegate people. And I may refer to the list of authorities I have provided to the chamber yesterday, the first part in relation to the background and cause of a conflict. On the fact that contrary to other Janjaweed leaders, Abd-Al-Rahman has no social, political, or economic situation. The victims insist on the fact that MET, to whom the defense compared Mr. Abd-Al-Rahman yesterday, I'm referring to the Janjaweed leader, now number 2 in the transitional government. So the fact that MET had no military training and that if he has money now, it's not because it comes from a wealthy family, but because of the pillages when he was fighting with the Janjaweed. Mr. Abd-Al-Rahman owns his nickname Kushab to the fact that he was a tough fighter, and that is exactly what led him at the top of the Janjaweed militia. It doesn't matter if he was educated or not, whether he received military training or not, whether his father was a Nazir or not, he made it to the top because of his operational abilities. It has nothing to do with a possible social lift referred to by the defense yesterday. Regarding the colonel of colonel's title, or the Abd-Al-Rahman in Arabic, victims insist on the fact that it should not be regarded as a comparison with the regular army titles. Indeed, for it takes from the word ajid, which referred to the rank of colonel in Standard Arabic, in Sudanese Arabic, it refers to a traditionally military chief in Darfur, and therefore merely demonstrates that Mr. Abd-Al-Rahman was indeed commanding over the Janjaweed. Second issue that I would like to address, Your Honor, is the legal arguments of the defense presented this morning in relation to the knowledge of the attack under Article 7 of the statute and knowledge of a conflict under Article 8 of the statute. First, on the knowledge on the part of a suspect that there was an attack against the civilian population and that his act was part thereof. The determination of the elements comprising the mens rea of crimes against humanity has proved particularly difficult and controversial. Nevertheless, the requisite mens rea for crimes against humanity appears to be comprised of two elements. One, the intent to commit the underlying offense, combined with, two, knowledge of a broader context in which that offense occurs. And I refer, Your Honor, to the Kupreskic trial judgment, paragraph 332. A list of authorities will be provided to the chamber during the lunch break. More detailed one. This element, however, does not entail knowledge of the details of the attack. It is sufficient that through his acts or function, which he willingly accepted, he knowingly took the risk of participating in the implementation of the attack. Tadic trial judgment, paragraph 656, 659. The accused, as it was for the trial chamber in Blaskic, in this case the suspect, need not have sought all the elements of the context in which his acts were perpetrated. It suffices that, through the functions he willingly accepted, he knowingly took the risk of participating in the implementation of that context. Furthermore, the suspect need not share the purpose or goal beyond the attack. It is also irrelevant whether the suspect intended his acts to be directed against the targeted population or merely against his victims. Accordingly, in our submission, Your Honor, the prosecution does not need to prove that the suspect chose his victims for their civilian status. The prosecution must show that the perpetrator, the alleged perpetrator, could not reasonably have believed that the victim was a member of the armed forces. However, and as a minimum, the perpetrator must have known or considered the possibility that the victim of his or her crime was a civilian. In the Kunarach case, the trial chamber of the ICTY stressed that in case of doubt as to whether a person is a civilian, that person shall be considered as a civilian. So it must be only showed that the alleged perpetrator could not reasonably have believed that the victim was a member of the armed forces. Given that the members of the respective forces on the ground were acting in a concerted manner, it suffices that the pre-trial chamber finds substantial grounds to believe that either the principal perpetrators or the ones on the ground at whose behest they were acting, meaning who were commanding them during the operation, were aware that their acts comprised part of a larger attack against the Fur population in the region. Therefore, we submit that the defense argument in this regard should be dismissed. On this first point, it is our submission that there is no reasonable possibility that Mr. Abd-Al-Rahman could not have known about the situation of the Fur civilian population in those areas. There is sufficient evidence to establish substantial grounds to believe that the suspect willfully pursued the goals of the attack against the Fur civilian population in the areas, and therefore also knew that his acts fit into the pattern of the attack. On the issue, Your Honor, that the suspect was aware of the factual circumstances that establish the existence of an armed conflict. The element of crimes provide a common mental element for each war crime under Article 8.2a. The suspect was aware of the factual circumstances that establish the existence of an armed conflict. This element is supplemented by the following interpretative clarification as to the mental element included in the introduction to the war crime section of the Elements of Crimes text. In particular, there is no requirement for a legal evaluation by the alleged perpetrator as to the existence of an armed conflict or its characterization. In that context, there is no requirement for awareness by the alleged perpetrator of the facts that establish the character of a conflict as international or non-international. There is only a requirement for the awareness of the factual circumstances that establish the existence of an armed conflict that is implicit in the terms took place in the context of and was associated with. Therefore, the pre-trial chamber in Katanga and Chui stated, same decision which was, I think, also recalled this morning by the defense, I quote, "The war crime of willful killing provided for in Article A2A Roman 1 of the statute also requires that the perpetrator is aware of the factual circumstances that establish that protected status of the victims. Thus, this is an important part, it is not necessary for the perpetrator to have made the necessary value judgment to conclude that the victim did in fact have protected status under any of 1949 Geneva Conventions. Is the Katanga and Chui confirmation of charges decision, paragraph 305. Mr. President, Your Honors, there is sufficient evidence to establish substantial grounds to believe that when
I had the Arabic translation. What's happening? Thank you. Please continue.
Mr. President, Your Honors, there is sufficient evidence to establish substantial grounds to believe that when directing attacks on the civilian population, as described by the prosecution, and when killing the civilian population, the suspect, 1, intended to kill civilians not taking direct part in the hostilities and the civilian population as such. 2, knew that in the ordinary course of events, the attack would include killings targeted at protected persons and unarmed persons, including women, children, and the elderly, most of whom could not have been mistaken for combatants, and civilian victims who belonged to the adverse party to the conflict. Such awareness can be inferred on an objective basis and in accordance with the precedents established by international criminal tribunals, as also previously indicated. To conclude, Mr. President, Your Honors, the prosecution has shown in the victim's view that there is sufficient evidence to establish substantial grounds to believe that Mr. Abd-Al-Rahman committed all crimes as charged, and therefore all counts should be confirmed. The victim's account of events corroborates the prosecution case. The defense has been unable to provide any valid argument, either in fact or in law, to challenge the prosecution case as presented. Pre-trial chambers of this court have consistently understood the evidentiary threshold established in Article 61(7) of the statute as requiring the prosecution to merely offer concrete and tangible proof demonstrating a clear line of reasoning underpinning its specific allegations. At the current stage of the proceeding, the Chamber is not meant to determine the suspect's criminal liability or lack thereof. Instead, at this stage, the Chamber is meant to assess whether sufficient evidence has been presented by the prosecution to commit the suspect for trial. Considering the entire evidence presented by the prosecution and the corroboration by the accounts of the participating victims, we submit that there is sufficient evidence to establish substantial grounds to believe that Mr. Abd-Al-Rahman committed the crimes alleged against him, reaching the standard of proof required by Article 61 of the statute. Victims therefore request the Chamber to confirm all charges brought against Mr. Abd-Al-Rahman and to commit him for trial. Thank you, Your Honor.
Thank you very much. Now it's the time for the other legal representative of victims, starting with you. I understand, Ms. Clooney, the floor is yours, please.
Yes, Your Honor. Mr. President, thank you very much. It is a pleasure and a privilege to be addressing you once again. I believe I have 15 minutes, so in that time, I will focus on the victims' views regarding the key issues that have arisen during this hearing, and I will try not to go so fast that I make the interpreters' lives too difficult. Mr. President, you have heard from the Office of the Prosecutor of the compelling grounds to commit this case to trial. And in my earlier submissions, I sought to illustrate the extent to which the views of the victims accord with the prosecution's case. As the evidence shows, the suspect in this case was not only commanding his men from afar, nor merely present, but as the prosecution put it on Monday, he was a knowing, willing, and energetic perpetrator who would show no mercy to his victims. We have now heard a detailed account about his actions, commanding thousands of troops, choosing the routes for fighters, ordering them to shoot and kill, supervising arrests and the loading of cars to execution sites, beating detainees with his axe and whip, and when he felt like it, killing them. We heard his words, prepare their graves, just shoot, just kill. Repeat for these people, maybe there are some you have missed. Don't leave me one person alive. Wipe out and sweep. Your Honours, these are merely illustrations, and my submission is that the evidence is more than sufficient to meet the burden required at confirmation. Your Honours, in my submission, the defence arguments about a supposed mistake of identity did nothing to change this conclusion. This chamber has made clear in its confirmation decision in Yekatom that this stage of the proceedings does not involve the full presentation of the evidence, and that you are generally not required to resolve any apparent contradictions in the evidence or address its probative value at this stage. And in any event, the prosecution has easily demonstrated, both in their written filings and before the court, that this suspect and Ali Khashayb are the same man. The suspect has indeed said it himself, and you heard this in the video that was played this morning. I can also confirm that none of the victims I have consulted since the beginning of this hearing have suggested that this court has the wrong man. Quite the contrary, they are elated to see him here. As one victim stated just this morning, I've been following the hearing, and the man sitting in that courtroom is Ali Khashayb exactly. We've seen him up close because he attacked and killed us in Mukjar and elsewhere. If his lawyer needs people to identify him and the court needs clarification, we, the victims, are ready to testify. And of course, Your Honours, this argument can be quickly and easily tested at trial when witnesses are in the courtroom. As I said in my opening, the victims in this case know Ali Khashayb. They knew him before the conflict, they saw him commit crimes during the conflict, and they would recognize him if they saw him again. Of course, the defense is free to raise any arguments they wish to raise. It is their duty to defend their clients to the best of their abilities, and of course, we all respect that. But I have to confess, this defense argument was rather difficult to understand. We heard, basically, that the man in this courtroom is not Ali Khashayb. So does that mean there is another man hiding somewhere who is Ali Khashayb, who the defense agrees should face trial for the 31 counts presented by the prosecution? Or are they saying that all prosecution witnesses and victims conspired to concoct uncannily consistent stories about a man who does not exist? And what then of the man who is in the courtroom today? Is the court being told that he was simply selling medication at his pharmacy while the charged events unfolded? If so, why did the defense not invoke a defense of alibi for the suspect under Rule 79, specifying where he claims to have been at the time of the alleged crimes and the names of the witnesses who can confirm this? Your Honours, I'm afraid that your analysis of whether the substantial grounds test has been met by the prosecution may not be taken much further based on what you heard yesterday. You heard that the suspect could not be the Janjaweed leader he is accused of being because he has a different tribal background to other Janjaweed leaders, a different military background to them, and because he was not as famous as the other leaders until he was subject to an ICC warrant. But it is not clear why any of these issues would undermine the prosecution's case. You heard that the suspect was a bicycle delivery boy and that he would have had to rise to a position of power so quickly that it begs the question of how such a rise to the top could take place in this time frame. There was even an ironic reference to the film Slumdog Millionaire. Your Honours, I'm afraid this argument is as spurious as it is insulting to victims. The trajectory to becoming a Janjaweed commander is not a precocious rise to the top. It is a precipitous slide to the bottom. There was also much discussion yesterday about what the suspect did in 2005 or 2012, events clearly irrelevant since they post-date the incidents described in the charges. You heard as well that the suspect's official title did not reflect what he is accused of doing in this case. Well, Your Honours, this court has affirmed an arrest warrant for crimes against humanity against the suspect's colleague, Mr. Ahmed Haroon, and his official title at the time of the warrant was Minister of State for Humanitarian Affairs. So clearly, official titles are not determinative of the issues you are dealing with. Nor is there a need for me to discuss the argument put forward that the suspect could not be Kushayb because Kushayb is a type of wine and this suspect is not a drunk. Your Honour, this argument simply does not warrant a further response from the victim's representative in the limited time available. Your Honours, the other defence argument is that there was no way the suspect could have known that, and here I quote something that the defence said this morning, no way he could have known that, quote, something bad was happening, end quote, without extensive legal training. And this is also, at best, I would submit, an issue for trial. Let us remember that the suspect is accused of hacking unarmed people to death with an axe, commanding men who shot people in the back as they ran away, inducing troops to rape young girls, torturing innocent farmers and young boys, and working with Janjaweed to burn villages full of defenseless civilians to the ground. I'm not convinced that the court will need much assistance in analysing the merits of this argument, but I'm grateful to the prosecutor and to my colleague from the OPCV for providing a detailed response to it earlier today. So, Your Honours, my submission to you is that the prosecution evidence was compelling, certainly sufficient for purposes of confirmation, and that nothing this court has heard from the defence changes that. Your Honours, I'd also like to note what Mr. Nichols, the prosecutor, said this morning. He stated that the prosecution will, quote, 100% continue to investigate, and that this would be with a view to potentially adding or seeking to add more charges in this case. And this is in response to some of the most important submissions I've made on behalf of the victims I represent, an issue of great concern to them. And so I'm grateful that the prosecutor has agreed that more investigations are needed and that a request for further charges could follow in due course. Your Honours, I'd like to end with two final points which are important to the victims. First, the victims have conveyed to me that accountability in this case means bringing the other suspects sought by the ICC to The Hague as well. The prosecution has clearly shown through their arguments this week that the Janjaweed acted pursuant to a state policy. We know that this court has approved arrest warrants for three of the top state officials, that's Bashir, Hussein, and Haroon. And we heard the prosecution describe the chilling testimony of witness P106, that the victims were told, quote, "You, Fur, kept saying, Allah, Allah, but your God will not protect you from us. Bashir is our God." So it is perhaps not surprising, Your Honours, that when asked about their views and concerns, some of the victims point to the empty chairs in this courtroom where they believe the other perpetrators should be sitting. In the words of one victim, quote, "I want those in power who are in so-called prison to be taken, put beside Ali Kushayb, and held accountable for the same crimes." Comfortable. It is as if we were reborn. Since 2003, the perpetrators made us feel like we were in a box. Seeing the perpetrators before the court, we feel we will be free and get our rights back. Another client explained, quote, "I am happy because the impossible became possible. Ali Kushayb appeared before the court." And finally, in the words of another victim who is an Umda or chief, quote, "We are so happy today because we thought the international community turned a blind eye to us and that our case fell on deaf ears. But finally, after 18 years, we feel that the international community will deliver justice to us, and this is all we want." Your Honours, the victims in this case are prepared to testify to this suspect's crimes, and they wish to participate in his trial. I stand with the victims in their march for justice, and I urge you to move this case forward to trial. Thank you very much.
Thank you very much. Now, Mr. Amin, Masal Khair, good afternoon. The floor is yours now.
قاضي الرئيس، حضرات السادة القضاة، يعني أحاول بقدر الإمكان أن أوجز في في هذا الوقت القصير لتناول بعض الردود على ما قام السيد ممثل الدفاع بتقديمها، وأبدأ به فيما يتعلق بما دفع به السيد ممثل الدفاع فيما يتعلق بأن أن المتهم قد اضطر إلى ارتكاب بعض الجرائم إذا كان ارتكبها، لأن هناك قوانين في الحكومة السودانية. هذه القوانين تقضي بعقوبة الإعدام في حالة تهديد الدولة أو عدم الامتثال أو عدم تنفيذ القوانين أو الإخلال بها. لكن على المقابل أضع أمام عدالة المحكمة أن أيضا هناك قوانين في السودان. هذه القوانين تأتي في مرتبة أعلى من مرتبة القوانين التي أشار إليها الدفاع، وهي تحظر مثل هذه الممارسات. وهذه القوانين أقصد بها هي مجمل الاتفاقيات والمعاهدات الدولية التي صادقت ووقعت عليها حكومة السودان، وأخذت ترتيبا أكبر من ترتيب التشريع الذي استند إليه الدفاع في هذا الشأن. وهنا أشير بشكل موجز إلى أن السودان كحكومة قد وقعت على العهد الدولي للحقوق المدنية والسياسية، وقعت على الاتفاقية الدولية لمناهضة التعذيب، صادقت على الاتفاقية الدولية للقضاء على جميع أشكال التمييز العنصري، أيضا صادقت على الاتفاقية الدولية لمنع جريمة الفصل العنصري، وأيضا الاتفاقية الدولية للطفل، بالإضافة إلى الميثاق الأفريقي لحقوق الإنسان. وجميعها اتفاقيات صادقت عليها الحكومة السودانية، وبعد التصديق أصبحت جزء من التشريع الداخلي وتأخذ مرتبة أعلى من التشريع الذي يصدره البرلمان السوداني. وبالتالي لا يمكن الاعتماد من الدفاع على أن هناك ثمة قوانين قد اعتقد المشتبه فيه بأنها تمثل تهديدا بالنسبة له. أما الدفع الآخر الذي تحدث عنه الدفاع والذي جاء بأن المشتبه فيه امتثل لتنفيذ أوامر الرؤساء كمبرر لعدم المحاسبة، وهنا أشار إلى قضية إديموفيتشي التي نظرتها المحكمة الجنائية الدولية الخاصة ليوغوسلافيا ICTY. فقط أحاول أن أذكر الدفاع بأن الوضع مغاير، ولا يمكن الاستنتاج بأن هذا وضع يماثل وضع السيد عبد الرحمن الشهير بعلي كوشيب، لأن بوقائع قضية فيدوميتش في محكمة يوغوسلافيا نسى الدفاع أن يذكر، أو ربما تعمد ألا يذكر، أن هذا الجندي كان قد رفض الامتثال لقرار القائد له عندما تم تشكيل الكتيبة التي سوف تقوم بأعمال تمثل جريمة إبادة جماعية، وأنه استشعر أن تشكيل الكتيبة جميعها جاء من عنصر واحد وهو عنصر الصدق، وأنه أعرب عن رغبته لقائده بأنه لا يريد أن ينضم إلى هذه الكتيبة، ولكنه أجبر إلى أن ذهب، ولم يتم إصدار الأوامر له إلا في ميدان المعركة، ميدان الحرب ذاته الذي يرتكب فيه هذا الفعل الإجرامي. وبالتالي لم يكن أمام إيبوفيتش إلا الامتثال لأوامر القادة التي يمكن أن يتم التذرع بها، وهذه حالة مغايرة تماما. إيبوفيتش كان يخشى من القتل الآن عندما قال له القائد بأنك إن لم تفعل فسوف تكون الرقم 101 للأشخاص المطلوب قتلهم. أما السيد المشتبه فيه عبد الرحمن كوشيب فنحن نتحدث عن أنه يخشى، لديه اعتقاد غير صحيح أنه يخشى من أن يطبق عليه القوانين التي تؤدي إلى الإعدام، وبالتالي هذا أمر لا يمكن أن يقبل على الإطلاق، لا سيما أنه يخشى من قانون، والقانون يمكن أن يكون هناك تحقيقات ثم محاكمات ثم طعون، ويعني هناك وقت كبير جدا لا يمكن التذرع بأنه كان يمثل خطر حال يهدد علي كوشيب فجعله يمتثل إلى أوامر الرؤساء، وبالتالي لا يمكن الاستنتاج أو الاستنباط من قضية المحكمة الجنائية الدولية في يوغوسلافيا لتطبيقها على هذا الواقع. الحديث الذي دفع أو تحدث فيه الدفاع وكان يعني لا يريد أن يصدق أو لا يريدنا أن نصدق أنه كيف لرجل بائع أدوية أن ينتقل فيصبح قائدا عظيما دون أن يكون له مؤهلات. هو ليس متعلم، هو كان محض رتبة ضعيفة وقليلة. في حقيقة الأمر هذا أمر طبيعي جدا في السودان، هذا أمر يمكن أن يحدث في السودان، هذا أمر يمكن أن يحدث في أي مكان في العالم، لأن المؤهلات المطلوبة لقاتل أو لشخص يعني يطلب منه ارتكاب جرم هي في الحقيقة ليست بحاجة إلى شهادات عليا أو رتب عليا، ولكنها بحاجة إلى أشخاص قادرين على تنفيذ هذه الأعمال الإجرامية. وبالتالي فكرة الانتقال هي فكرة ممكنة، هي فكرة يمكن أن يتم استحضارها، لا سيما أنه كان قائدا لميليشيا مسلحة. الركن الآخر أو الدفع الآخر فيما يتعلق بالحديث عن توافر العلم لدى المشتبه به وفقا لأحكام المادة 8 فقرة 2 ألف. لن أطيل لأن زميلتي بولينا استفاضت في هذا البند بدرجة كبيرة، ولكن فقط أكرر بأنه يكفي توافر العلم بأن هؤلاء الأشخاص هم جزء من النزاع المسلح. وأعتقد أن الدفاع قدم لنا بطبيعة الحال عندما أراد أن ينفي الشبهة العسكرية أو شبهة أن المشتبه به كان جزءا من تكوين مسلح، فأشار على أنه كان بائعا مشهورا يتاجر في أعمال الأدوية المتعلقة بالحيوانات، وهو أيضا محلي، وبالتالي هذا الشخص كانت له العديد من العلاقات. هو مواطن محلي، هو تاجر، وبالتالي علاقاته تسمح له أن يعلم تمام العلم بأن الفور هم جزء من هذا النزاع، وأن المتمردين هم جزء من النزاع، وأن الحكومة ترغب في ذلك، وأن الحكومة طلبت منه ذلك، وهو بالفعل نفذ ما طلبت منه الحكومة. وبالتالي يتوافر ركن العلم المتمثل في المادة 8 2 ألف. أخيرا يعني أرغب في أن أشكر الادعاء أيضا بأنه منحنا أمل بأنه أفاد بإمكانية توسيع دائرة التحقيقات والتحري لتشمل جرائم أخرى. نرى كممثلين الضحايا أننا بحاجة بالفعل إلى إضافة تلك الجرائم، وسوف نساعد في إثبات تلك الجرائم في المرحلة اللاحقة. سيدي الرئيس، حضرات القضاة، أرواح الضحايا وأصوات النساء المغتصبات الذين وقعوا تحت سيطرة وممارسات العنف من المشتبه فيه تناشدنا جميعا وتحوم وتحلق فوق هذه القاعة التي نجلس فيها الآن. تناشد عدالة المحكمة باعتماد التهم ضد المشتبه فيه عبد الرحمن الشهير بعلي كوشيب، لا سيما وأن هناك أدلة قوية ومسندة قدمها الادعاء العام يمكن أن تمثل وهي بالفعل تمثل أساسا جوهريا للاعتقاد بأن السيد علي كوشيب عبد الرحمن الشهير بعلي كوشيب قد ارتكب كل الجرائم المذكورة في مذكرة الادعاء، ونفذ كل الأفعال الإجرامية التي ذكرتها الاتهامات الواردة بمذكرة الادعاء. لذلك التمس باعتباري ممثلا للضحايا باعتماد التهم وإحالة هذه الدعوة إلى المحكمة الابتدائية. وشكرا.
Thank you very much, sir.